Institute of Justice in Warsaw, and it is a great opportunity for us. I think I can say it on behalf of all team members to be participant of this project. It is a great honor for all of us. And today we would like to make our kick-off seminar. That is, we would like to put an emphasis on the research concept of the team and the research concepts of the team members. That is the reason why now I try to share my PPT with you, if I may, because as a first presenter, I try to make an overview about the whole research concept of the group. My first question, whether do you see my PPT or not? Okay, thank you so much.
Yes, we see it.
Thank you so much for your reflection. I am a professor at the University of Miskolc here in Hungary. I'm also head of department of the Ferenc Márdai Institute, and I am honored with the team leader status of this group. That is the reason why now I try to summarize the almost 1 year research activity of the Legal Protection of Farmers group. Okay, and first of all, I would like to notice that after the beginning of this research group, we have received a kind of collection of the given topics connected to the legal protection of farmers. These concept directions, they were determined by the Institute of Justice, and they summarized these concept directions in 10 points. Now I would like to present these points. They are the following. The first one is the competitiveness of agriculture, the environmental changes. Now I try to summarize the essence of the concept directions. The third one is about the illegal practices in food supply chain. The fourth one is unfair market practices. The fifth one is European Green Deal. After that, the next one is livestock welfare, land market, agriculture code, young farmer, and last but not least, food waste. As to these concept directions, my first remark that they are quite topical issues, in my opinion, not only of course in Poland, but also in Hungary and maybe in other parts of the European Union and of course Central Europe. I have a kind of hobby, that is, I collect these kinds of concept directions deriving from decision makers and other bodies. I always try to collect this kind of lists about the topical issues, also for example from the Hungarian decision makers, that is the ministries, or if I have an option for example from the European Commission and other European institutions. This concept directions list provided by the IVS, I think it's quite useful for experts dealing with agriculture area. That is, this list is a quite valuable topics list. However, I think the participants of the present meeting can feel, can assess these concept directions, and the conclusion is quite clear. That is, they are wide-ranging themes. That was not so easy to analyze, to assess all of them during our research period. It is approximately an 8-month period with this capacity. Therefore, we were forced to somehow find some joint points, some common directions, and it was a hard challenge for the research group members to do that. But of course, we can reach this goal somehow. Before the conclusion of the research team, we made, of course, some evaluation, some assessment. One of the potential assessment, and I prefer this assessment, this evaluation, it was via the lens of the CEDR research directions. What does it mean, CEDR and its research direction? CEDR, this is a, we can say it, pan-European association. This is a civil association. The residence of the CEDR, this is a committee Européen de droit rural, that is agriculture, European Commission of Agriculture Law or Rural Law, and its residence in the French capital, and it has numerous association members from all around of Europe. And some years ago, the CEDR kept a meeting with the representatives of the European Union institution, that is with the representatives of European Commission, Parliament, and also the Court of the European Union, the Court of Justice of the European Union. And during this meeting, we focused on the potential scientific research directions, which can be useful for the European institution. And via this meeting, we try to somehow determine this potential and useful direction. At that time, we could determine 3 fields which are extremely cardinally important for the European institutions. One of these directions was the regulation in countries, in member states, agriculture and land law. The second one was agricultural competition law, and the third one is connected to legal questions of agricultural subsidies or supports. Taking into account the CEDR direction, I try to analyze the Polish initiative as to the concept directions, and my assessment was the following. As to agricultural land, there are, of course, some directions among which we can find this relationship with agricultural land law. For example, the land market itself is absolutely, it's clearly connected to the CEDI directions and vice versa. Or, for example, young farmers support. One of the potential field or area, it can be via the agriculture land law itself. The situation is, however, similar in connection with agriculture competition law as to the illegal practices in food supply chain or unfair market practices. I think the Polish initiative is quite valuable. And of course, we can find similar relationships also with agriculture supports. For example, the previously mentioned young farmer and European Green Deal issue or the competitiveness of agriculture could be mentioned similarly. Maybe this assessment, it can be a kind of proof that this concept directions of Institute of Justice, it's valuable not merely from Polish or Hungarian perspective, but also quite relevant from an European level as well. But unfortunately, it does not provide a concept for us how to deal with these colorful directions of the Institute of Justice. Therefore, I somehow try to categorize the concept directions of the Institute of Justice, and I established some groups from these concept directions. And now I would like to present these potential groups of the issues. In my opinion, these issues, these groups, they have their own logic. They are the following. One topic is agriculture code. I think this agriculture code or systematization of agriculture relationships, it's a quite important and theoretical issue. It's obvious that it's extremely important in Poland. Sometimes in Hungary, we also have ideas, debates about this topic. Maybe an interesting notice to this topic from an Hungarian perspective, that the Hungarian fundamental law has numerous regulations connected to agriculture issue. In this sense, the fundamental law of Hungary also can provide a kind of systematization of this topic. But as I first mentioned, it is a theoretical issue. The next group, in my opinion, can be assessed from the perspective of sustainable development as well, and especially via or through the pillars of sustainable development, that is the ecological pillar, economic pillar, or social pillar as well. That is, for example, the environmental changes or European Green Deal, their focus is especially ecological. As to the competitiveness of agriculture can be connected to economic pillar of the sustainable development. And young farmer, it is a little bit about the intergeneration relationships in agriculture. That is, it can be considered as a kind of social pillar of sustainable development. The next three topics, land market and or illegal practices in food supply chains, unfair market practices, they are, from my point of view, they are hardcore topics of agriculture law. In a certain sense, they are the essence of agricultural affairs. Therefore, they are part of the classical agriculture topics. The next two topics, the livestock welfare and food waste issue, they also have a kind of connection to the previously mentioned sustainable development approach, and especially the ecological pillar. As to the livestock welfare is about, in a certain sense, about animal protection, and food waste can be also connect to waste management issue. After this kind of categorization, I try to somehow grab some potential way how to build up the research concept of our research team, especially focusing on the monograph itself, because the monograph, I think, it is the most systematized part, or it should be the most systematized part of our research program. And I think that we could determine maybe two types of approaches for a monograph. The first, it's connected to the classic agriculture question. And in this sense, the question of agriculture code, land market issues, illegal practices, and so on and so on, they can provide an approach, and the sustainable development affected topics, they can provide another one. Of course, this systematization, maybe it's not as clear as I previously tried to present. For example, the competitiveness of agriculture issue, it can be also categorized into the group of the classical agriculture law. However, after that, the question was, it was a kind of option for the team members whether to choose the classical approach or sustainable development approach, and our decision was relatively clear. As to the monograph, now we can focus on classical topics. Taking into account, however, that this research is not only about the monograph, but there are other contributions from the research team members. That is, there are also papers, also this opening seminars presentation, or international conference presentation, and dissemination events. Of course, we could also deal with other topics in other forms of our contribution. But as I previously mentioned, here, first of all, you can see what is the concept of a monograph. At this moment, there is only a working title, maybe main pillars of the legal protection of farmers, systematization, holding structure, and commercial issues. We hope that Dr. Liss is going to be the author of the first part of the book. After that, in the part 2, the contributors, they are Rala and me. And as to the third part, there are Professor Adamus and Dr. Nevertheless, you can see other topics and other commitments from somehow. That is, there are also other topics. Almost all topics are assessed in a certain way by the team members. Maybe you can see that competitiveness of agriculture is not, but in reality, when we deal, for example, with land market issues, with unfair market practices or subsidies issues, Of course, we also affect the competitiveness questions, affairs of agriculture, which is not part of our research activity. It may be the food waste, but others they are affected by the team members. Ladies and gentlemen, thank you for listening to this presentation. I was honored for your attention. Colleagues, after the summary of the research concept, I would like to call Dr. Liss to deliver. I hope that he is here now. Dr. Liss. And if I may use a phrase from the period of COVID pandemic, the screen is yours.
I have a presentation. I will not read all the slides.
We can see it. We can hear you.
Evolution of agricultural legislation in Poland. There are two European models for development of agricultural law of Roman countries comes to a greater extent from civil law and was formed on the basis of the specifics nature of civil law contracts involving agriculture relations. German agricultural law, on the other hand, has its origin in public law format in connection with land reforms and granting property rights. The problem of the agricultural code belonging to the private legal sphere is quite a complicated issue. Civil law relations by definition occur between equal subjects of the law. In administrative law, on at the other hand, the basic feature is the superation of the administrative law body over the party to the proceedings, where the body decide with authority on the legal situation of the farmer. Of course, administrative law give the party many instruments of protection, which has some advantages, but nevertheless, the ruling position of the authority still remains. The first attempt to codify agricultural law was made in the late 20s. Commission presents a proposal for an agrarian code after only 6 months work, although the task was not easy. After transforming it into legal concept, the author formulated an idea that still proves to be alive today. Jaworski was not entitled successful in pleasing the proposed regulation for the agrarian code within the framework of public law. Yet this was an original project. Professor Jaworski's views should not be identified with either the position of the government or the commission. The second attempt to codify agricultural law was made more than 40 years later, only in the first half of 1970s, in a completely different socio-political, economical, and legal reality. Only on this basis would it be possible to draft an agricultural code which would not include an agricultural provisions from the civil code. The creation of an agricultural code in Poland has been announced since December. The 2022, one of its initiators is Janusz Wojciechowski and Grzegorz Wojciechowski. It is intended to regulate in practical the task of public authorities in relation to agricultural activity and rural development, the conditions of farming and agricultural activity, the principle of protection and crisis. Support for farms, especially family farms, civil and legal relations concerning farm, as well as other rights and obligations of farmers and system of their protection. On 27 of January 2023, a joint meeting on the draft agricultural code was held by three parliamentary groups. Chapter 1, Scope of Regulations. Chapter 2, Tasks of Public Authorities relating to agriculture. Chapter 3, Agriculture Activities. Chapter 4, Agricultural Holdings and Family Farms. Chapter 5, A Farmer. Chapter 6, entitlement to acquire an agricultural holding or an agriculture real estate. Chapter 7, control of agriculture holdings. Chapter 8, protection of agricultural holding in court and administrative proceedings. Chapter 9, crisis support. Chapter 10, protection of agriculture holdings if divided or of shared ownership. Chapter 11, separate social security plan for farmers. Chapter 12, farmers ombudsman. Chapter 13, final provisions. Link to the full draft agriculture code. This is my address, mail. Thank you very much.
Dear Dr. Luis, thank you so much for your presentation. I would like to emphasize that this initiative of Poland is quite interesting also for us, for Hungarians. Therefore, I'm waiting for other details about the developments concerning this issue. And now, in your presentation, agriculture holdings, they were also mentioned as part of this agriculture code project. And we would like to focus on this issue now here. I would like to call Dr. Horniak. Dr. Horniak, the screen is yours.
Thank you very much. Just a few moments. I'm not sure, do you see my PowerPoint presentation?
At this moment, no.
Or not yet?
Not yet.
Okay, thank you. Just a moment. And maybe now?
No, unfortunately not. As to the technical issues, first of all, of course, I opened the file, the PPT itself, and after that, I used this switch with this computer pictogram or logos.
Yes.
Yes, at this moment, I can see that yours is not switch on. Az rá kell klikkelj, sorry, arra.
I know. I clicked it, but it's only spinning.
Maybe you should switch on
Now
as presenter. Yes, now it's
Now?
okay.
Yes.
Yeah,
Maybe
it's got. Yeah, it's
okay,
okay.
and now the full screen is with my PPT.
Perfect.
Yes. Okay, thank you very much. Dear professors, dear colleagues, dear ladies and gentlemen, thank you very much for this opportunity to the Polish-Hungarian Research Platform. I think it's a very good opportunity for me and for this whole research team, research group. I am Zsófia Hornyák from the University of Miskolc. I am an assistant professor at the University of Miskolc, and also I am the head of the Dean's Office at the University of Miskolc, Faculty of Law. And today I would like to speak about the legal background of acquisition of agricultural lands and holdings too in Hungary. And first of all, I would like to say some words about the background, and we have to go back to 2004 when we joined to the European Union, because our accession treaty said that we can keep our prohibitions on acquisition of agricultural land by natural persons who are non-residents or non-citizens of Hungary, and by legal persons till a time frame, and this time frame was 7 years first. It means the land moratorium, but we had the opportunity to lengthening this time frame, maximal plus 3 years. And of course, we try to do this. And the European Committee acquired our request. It means that the land moratorium in Hungary ended at the 30th April of 2014. And it means that we need a new land transaction regulation in Hungary. So we have a new act on land transaction, and this act came into force at 1st May 2014. But the current regulatory framework means at the moment that we have a strategical document. This is the National Rural Strategy, and also we have some legal background, some acts, but in different levels. What does it mean? So the fundamental law, our fundamental law have some articles about the agricultural land, and we have also some implementing acts. It means that the Hungarian Parliament adopted these acts with 2/3 majority. So it has a little bit much more meaning. So it's a little bit meaningfuller than the other so-called normal acts. Of course, we have some acts which regulate this area, so the agricultural land and the acquisition of agricultural land, and of course the agricultural holdings. And of course, we have some government decrees. But I would like to speak about the main acts which regulate the acquisition of ownership of agricultural land. And I would like to say some words about the acquisition of agricultural holdings too. So first of all, some words about our fundamental law. So the Article P is very important for us, because this article says that the natural resources, and particularly the agricultural land, and it is so the first mentioned from the natural resources. So the agricultural land is the nation's common heritage, and it means that all of the persons and of course the state has the obligation to protect and preserve it for the future generations. And that's why I said the Article P of our fundamental law in his second subsection that we need a regulation, and we in this subsection are three areas which we have to regulate in an implementing act. These three areas are the land acquisition, the regulation about the agricultural holdings and also family farms, and the third is the organization of integrated agricultural production. But at the moment, we have only one really so-called implementing act. It is the Land Transaction Act, and the other two topics are not regulated in an implementing act. We have only a partly implementing act, the so-called Act on Family Farms, but it doesn't mean the whole regulation about our agricultural holding system. So it's only a part of this system, and we are waiting for a real regulation about the agricultural holding system. And we have some normal acts on this area, and we can see on the slide that we have so many acts on this area. We have a so-called Land Act. It means it's related to the Land Transaction Act, and some certain provisions include this act. We have another act from 2014, which main aim is to prevent the legal transactions aimed at circumventing legal provisions restricting the acquisition or use of the agricultural land. And it's very interesting that our criminal code has a fact that so-called unlawful acquisition of agricultural and forestry land. And we have two quite new acts from 2020 and 2021. One is Act on the liquidation of undivided common ownership of land, and the other is the Act on the transfer of agricultural holdings. So we can see that we have a very diversified regulation for this area. So we doesn't have any agricultural code. We have so many acts on this area, and we have to say that it's only the acquisition of agricultural land and the regulation about agricultural land and agricultural holdings, and of course the agricultural law has also other topics. But in my presentation today, I would like to speak about the main rules and main aims of the Land Transaction Act. We can say that this act is the basic, it means the basis of our land transaction regulation. I said that it's an implementing act, and I have to say that the object of our regulation is the agricultural land. So not the agricultural holding, but only the land. And it will be a very interesting question when we will have an regulation about the whole agricultural holding system. But now we can say that the agricultural land means the object of our land transaction, of our agricultural transaction regulation. And now I would like to speak about some basic instruments of this act, because I would like to share some thoughts about the basic regulation, and in the future I would like to examine the details of this territory. So I would like to highlight some purposes of the Land Transaction Act. One of this is that the main aim of the legislator was that the person who can and who would like to manage the whole agricultural land, so he will be able and to acquisite the agricultural land. And all of the rules of this act would like to do that, to help that. And the other purpose of the act was to help the role of the medium-sized farms at the Hungarian agricultural market. And this act is against the fragmentation. And we have some special categories in this act. For example, the farmer, he will be this person who can and who would like to manage this whole thing, this economy and the whole agricultural land. And now in this act, in this Land Transaction Act, have the clear definition of this person. So it means that farmer shall mean any Hungarian natural person or an EU national who are registered in Hungary and who has a professional qualification in agricultural or forestry activities. But so in the absence of that, other person can be also a farmer, for example, who has been verifiable engaged in the pursuit of agricultural and or forestry activities and other secondary activities in his or her own name, at least 3 years. But in absence of that, it can be farmer who verifiable holds membership for at least 3 years in an agricultural producer organization in which he has at least 25% ownership share. I said that the object of our regulation is the agricultural forestry land, and we have a definition in the Act for this land, but it's very interesting for us, the agricultural holding. So we doesn't have a regulation about the whole agricultural holding system, but we have a definition in the Land Transaction Act for this agricultural holding. It means a basic organization unit of production equipment and other means of agricultural production operated with the same objective and functioning also as a basic economic unit by way of economic cohesion. And some words about the Land Transaction Act. So the Act governs the acquisition of ownership of land, the use of land, monitoring the restrictions on the land acquisitions, and also have some provisions on local land commissions. And this Act applies to all lands located in the territory of Hungary. And the scope of this Act cover the acquisition of ownership of land under any title and by any means. But of course, there are some exemptions from this. It means that not including the scope of this Act, the acquiring by way of, for example, intestate succession, and it will be a very interesting question for me in the future in this research. Yes, and the basic statement of this act is the person can acquire the ownership of land who is a Hungarian natural person or e-nationals and who are a farmer. And it means that he can acquire 300 hectares. This is the land acquisitions limit. And the other persons who are not farmer can only acquire 1 hectare of this land. There are some exemptions here too. It means a close relative can also 300 hectares acquire. This is some other important question that the acquiring party have to make some statements that he will use the land and he has no fee or other debt owed in connection with land use, and he wants to use and he will use the land for not for other purposes for a period of 5 years. So he have to make these statements at the time of the acquisition of land. And we have another new instrument in this regulation. It is the approval by the competent authority. It means that the contracts for the transfer of ownership of land shall be approved by the agricultural administration body. So these are the basic elements of our land transaction regulation. And it will be an interesting question for me in my research in this group, that how can we put the agricultural holding maybe in this system, and how we'll see the whole generation change in this legislation. So it will be a very interesting and important question that a younger farmer and the younger generation, how can acquire the agricultural land and the agricultural holding also. There are 2 ways. So it will be interesting and important for me that in the life of the elder farmer, how can a younger farmer acquire the land, and of course in the death of the elder farmer, how can inherit the younger farmer this whole agricultural land or agricultural holding. So it will be the main topic of my research in this program. And thank you very much for your kind attention.
Dear Dr. Horniak, thank you so much for your contribution. I think that via your presentation, it's obvious that the approach of the Hungarian legislator as to the regulation of agricultural lands and holdings is quite strict. In this region of Europe, however, sometimes there are different approaches. There are more liberal approaches or more strict approach. The Hungarian approach is quite strict, and as far as I know, the Polish approach is similarly strict. Therefore, now there is a kind of meeting of the same approach. I would like to call Dr. Strala to deliver his presentation about his research concept, also connected to agricultural lands and holdings. Dr. Strala, the screen is yours.
Thank you very much. Firstly, I would like to ask whether my presentation can be seen. Okay, thank you very much. Dear professor, dear colleagues, dear participants, I would like to deal in this presentation with some introductory remarks. My name is Marek Strzała, and I'm the associate professor at the Law Department, Law and Administration Department of the Jagiellonian University. And I will, in this project, deal mainly with the restrictions and prohibitions about the acquisition of the agricultural land. Before, in the following seminars, in the next presentations, I will be dealing with some particular regulations. For example, acquiring agricultural land by the legal entities. But this first seminar, I would like to talk about the definitions and the aims of the laws. In fact, in Poland, the main aims, the main regulations about the farms, agricultural land, and the shape of the agricultural land preferred by the lawmakers in Poland are regulated in the different statutes and different laws. The most important laws, it is mainly, of course, the Constitution of the Republic of Poland of April 1997. The second regulation is the Polish Civil Code of 23rd of April 1964. The most important and the main body of the regulations about the restrictions about the acquisition of agricultural land are included in the law of 18th of April 2003. And it is what is more important, it was widely amended by the law of the 14th of April 2016, which took force on the 1st of May 2016, because Poland had the same period of time to prepare for the EU nationals and other entities for buying land, as Hungary, as we hear in the presentation of Dr. Horniak. So, what are the aims of the laws? From the one article, we can see that the preferred way of agricultural activity is the family farm. It is some kind of main goal of the particular laws, and this aim from the Polish Constitution can be linked, can be found in the particular regulations. In the 1990, in the year 1990 in Poland, there was abolition of the prohibition of the acquiring agricultural land. In the articles 160, I believe, 2 or 3, there was a prohibition to acquire agricultural land by other people than individual farmers. There were some exemptions, of course, but after the 1989 and new situation, new way of dealing with the agricultural and the civil law and the commercial law, after the transformation, after the communist period, there was a view that it should be more liberalization in this area of the acquisition of agricultural land. So these prohibitions were in the Polish Civil Code and were abolished in 1990s. As far as justification is concerned, there was only this point 13 of the justification of the draft, abolition of objective and subjective restrictions in the field of real estate trading. In fact, there was no further justification for this liberalization of acquiring agricultural lands. And in the law of the 2003, in the abbreviation UKUR, in the original text, the aims of this law was regulated. And the most important, improving the structure of farms, counteracting excessive concentration of agricultural real estate. These were the main goals of this law. In 2016, in this famous amendment, the 2 changes were done in this law. First, a new preamble was added before the Article 1 of this law, we have this part of the preamble, and you can see that the main goals here are the strengthening, the protection and development of family farms. They can be linked to the Polish constitution. And the next one, the proper management of agricultural land, and it will result in the restrictions concerning the abilities of farmers to acquire land, their abilities that enables them to acquire agricultural land. And amendment in 2019 to the same law of the 2003 added 3 more goals in the Article 1, and the last one is active agricultural policy of the state. And this active agricultural policy of the state, it is mainly conducted by the decisions of the authorities to accepting that an entity can acquire agricultural land. As far as this famous amendment from 2016 is concerned, the justification of this law's draft is very complex and deals with many issues. I don't want here to cite the whole justification. In fact, these 2 paragraphs are only the excerpt from the very long document. But the main goals, as highlighted here, is that agricultural land should be treated as a non-reproducible public good, and that should be subject to specific legal regulations. The next goal is that the draft Act on the protection of agricultural land in Poland against its speculative purchase. So the main goal of this amendment is that the land should be bought only for conducting agricultural activity and not for earning more money because of the appreciation. I missed the word. The land will get more and more costly, so not for the speculative purposes. And the other thing is that this regulation should be, in fact, beneficial for the development of this one. The second part of today's presentation, I would like to present the 3 main concepts, the 3 main definitions which are used in this very important law of 2003. The first one is the agricultural land, the second is the agricultural holding, and the third one is the agricultural activity. As far as this first concept is concerned, agricultural land, we have the legal definition, Article 46.1 above of the Polish Civil Code. It has important meaning for multiple regulations in many parts of the Polish civil law. For example, for the preemption right, for the definition of the agricultural holding. So this concepts are linked together. The severance of the co-ownership of the agricultural holdings, and the famous regulation of the inheritance of after the people who died before the 14th of February 2001, because before that date we have the very complex regulation about who is entitled to acquire, to inherit agricultural holding from the late person. And I will cite the translation by some kind of the researchers from Poland. But the one important thing that is missed in this first translation is that, in fact, in the exact wording of the Polish Article 46.1 above point, there is a connection between the agricultural immovable property and agricultural land. And what it means? It means that the agricultural immovable property can be only deals of land, because in Poland, immovable property can be, for example, buildings and parts of the buildings. And this definition is decisive because only lands can be agricultural real estates. And there is a debate, for example, as we can say about the lege ferenda motions, that some part of the Polish jurisprudence ask for deletion of this land approach, and it will, for example, may result in that the agricultural holding, for example, can be without consisting any land in it. So another important thing in this definition is that it has its own prerequisites. And it means that this land cannot. It's irrelevant whether this land is included in some kind of the register of agricultural lands, in any plans. It is an autonomous definition in the Polish Civil Code. Another thing in this definition, which is problematic, is that there is no minimum area that can constitute an agricultural land. For example, not 1 hectare, but 1 square meter theoretically can be treated as an agricultural land. So there are debate whether this minimum amount of the land should be included in the definition. And another motion from the doctrine is that there should be introduced some regulation about the cessation of this special status of agricultural land, because there are none, and there is the debate whether land which started to be agricultural can cease to be agricultural land, and it's not the administrative way of deal with this. Another thing is that this law on restrictions from 2003 have its own definition of the agricultural land. So one of the proposes is that we should make one definition and not the different definition for the different laws. It will be much simpler to put this law into action, and this will be especially described in our next meeting. The second concept is called agricultural holding, and it has its own definition in the Polish Civil Code. I have the translation done by the researchers. What's interesting, it is completely irrelevant of ownership. It's agricultural holding, no matter who owns the lands or forest lands, buildings on or other parts. If there is in reality link about these assets, they are creating the agricultural holding. And so once more, this is the autonomous definition. No other regulations, no other prerequisite outside this definition are needed to be agricultural holding in the Polish civil law. The same thing, we have a different definition of agricultural holding in a couple of the statutes. For example, once again, the law from 2003 has its own definition about the agricultural holding. And now we have this minimum acreage of this land, it's 1 hectare. And in other laws, for example, in the tax law, in the statutes about the taxes, we have a separate definition of agricultural holding. So this is this concept of introducing the agricultural code will probably deal with making this definition more coherent about the within the different statute, different laws. The third concept, it is the agricultural activity, and it has its own definition in the law of 2003. It is defined as the production activity in the agriculture in the field of plant or animal production, and including horticultural, fruit, and fish production. So it's a very wide definition of agricultural activity. And once again, there is a different definition in the different laws. And once again, in the tax law, we have more examples of the agricultural activity. For example, in the law on the personal income tax, there are cultivating fungi, breeding and production of breeding materials for animals, birds, and useful insects, for example. There are much more complex definition. And why these definitions, why these concepts are important for our next seminars? Because the main regulation included in the law of 2003 in the wording after amendment in 2016 in this one main article that deals with the prohibition and restriction about the acquisition of agricultural land, all three definitions are important because after 2016 in Poland, agricultural land can be mainly acquired only by individual farmer. There are some exemptions, for example, for the denominational legal entities and the state entities, legal entities, some kind of scientific legal entities, but mainly only individual farmers can buy agricultural land. And what is the definition of this agricultural individual farmer? An individual farmer is a natural person who is the owner, perpetual usufructuary owner on lease of agricultural land, which total area not exceeds 300 hectares. So this is the similarity with the Hungarian law, holding agricultural qualifications and residing in the commune where one of the farms is located for at least 5 years of agricultural real estate, constituting agricultural holding and running the agricultural holding personally during this period. What means to be running the agricultural holding? We have the definition with the third concept. An individual is seen as conducting agricultural holding if he or she personally runs a farm, works on this farm, take all decisions concerning agricultural activities with the definition mentioned before. And this maximum area is 300 hectares once again, and mainly the acquiring by other entities requires special permission from the authorities. And this is another similarity between the Polish and the Hungarian agricultural law. And I would like to tell you much further about the particular regulations in the next presentation. However, we will deal once again with these three main definitions. Thank you very much for your attention.
Dear Dr. Shala, thank you so much for your contribution. And now, taking into account the concept of the planned monograph, that is, we started with theoretical issues of the potential agriculture code. After that, we continued with the agriculture holdings and lands regulation. And now we can see numerous similarities between the Polish and Hungarian approach. Now we would like to concentrate on commercial and civil affairs connected to agriculture farmers' life. And now I would like to call Professor Adamus to deliver his presentation about this third part of the monograph, and of course about its concept, research concept. Dear Professor, the floor is yours.
Thank you very much. My question is how to make my presentation visible to you. and I have the answer right now. Can you see my presentation?
Yes, definitely.
Okay, so thank you very much. Thanks a lot for inviting me to the group of researchers. I'd like to present my individual concept of research during the work for the team. Just a second, I have to. Okay. As a part of my individual research, I'd like to consider changes in civil law to protect farmers. Should I explain that in Poland there is the principle of unity of civil law? So that means that commercial law is just a specialized part of civil law. So when I'm saying about civil law, I'm having on my mind as well commercial factors as well. I'd like to start with the bigger picture of my research plan. I'd like to go to the future of law with 5 levels of my consideration. In the first issue, I'd like to think over the need of replacing or amending or changing regulation of a farming contract in the civil code. I think that the regulation is a little bit outdated because the civil code is old, a lot of things has changed, so I think that we should start discussion about possible changes in the civil law in order to make regulation better and more modern. In the second level, I'd like to discuss the problem of how to strengthen, or if we should do it, a legal status of a farmer who is a natural person in commercial relationships. I think that we could find some ways to get to the goal. I'd like to discuss these possibilities. In the next level, I'd like to discuss the possibility or the need of creating a new kind of a security for farmers, which will be easy news, which will be very friendly for farmers. And of course, it should be very simple in order to be popular in practice. I think we could call it agricultural deposit, and I'm going to present my ideas in this respect. In the next level, I'd like to start discussion about enabling a registered pledge on agricultural crops. I'm aware of the fact that it's possible right now, but I think we should amend the act dealing with registered pledge in order to allow new proceedings for farmers to use registered pledge in a very easy way. And of course, we need a special procedures for creditors in order to allow them to exercise their rights. And the last issue in this section is how to introduce new forbidden types of unfair competition bids against farmers, which could protect the farmers in the market against unfair competition. It is the first part of my research plan, and the second part is about bankruptcy. I'd like to discuss the possibility of simplifying bankruptcy and restructuring proceedings for farmers. Nowadays, it's possible for farmers to start restructuring proceedings or consumer bankruptcy proceedings if they are natural persons, but the proceedings are very complicated. I think that Polish insolvency law is on a very good level if we consider structure of the law, but I'm afraid it's a bit complicated, and in order to be in better use in practice, we have to make some simplifications of the proceedings. It's quite easy to do so. I hope we can discuss this matter later. The most important question, I think, is do we need changes in agricultural regulations in Poland? I think the answer is very easy to give. Agriculture is of strategic importance for economy and security of the state. And if we look at the regulation, we can find some regulations which are outdated, some instruments are missing, some legal regulations need to be simplified. And finally, we can jump into the conclusion that quality of civil law has a direct impact on commercial life and commercial activity. So we should give the farmers as much as possible of good law in order to help them in their activity. I'd like to pay your attention into a very important document. It's called Legal Guide on Contract Farming. It was issued in Rome 2015. There are 3 worldwide fabulous organizations behind this document. I mean, International Institute for the Unification of Private Law, Food and Agriculture Organization of the United Nations, and International Fund for Agricultural Development. And the aim of this document is not to present a kind of a model law or suggest any changes in law. The purpose of the guide is to show the reference for good practice in farming contracts. I think that if we discuss the possibility of changing the law in Poland, we should take into consideration the results of this document and examine this document very carefully, because it could be very helpful in giving the proper balance between the position of a farmer and of a contractor in farming contracts. The question is, what requires changes in civil law in Poland? I think that one of the basic regulations of Polish civil law concerning farmers is farming contract. The next question must be, what is a farming contract? Well, it's a story of 2 parties. On one side, there is a farmer. On the other side is a contractor. Farmer's obligation is to produce stipulated goods in the future, and if the goods are produced, he is obliged to transfer them to the contractor. On the other hand, the contractor is obliged to pay a price, a fixed price, and to collect produced goods. Of course, there could be some additional services from the contractor to the farmer, but of course it depends on single agreement between the parties. The question is, what's the difference between a farming contract and the contract of sales of goods? The answer is very easy. The contract of sales applies to existing goods. The contract of a farming contract is to goods which are emerge in future. So we can see that this kind of agreement is very risky for farmer, because we are making agreement about future goods which are under agricultural cycle. I'd like to show the picture of the parties of the contract. On one side we have a farmer. A farmer can be a natural person or a legal person, and there is some mess in the Polish regulation, I think, and we could manage this problem as well and discuss this problem, because in the light of the civil code, a farmer who is a natural person, in most cases, he will be treated as an entrepreneur. But in the administrative law, in fact, a farmer who is a natural person is not an entrepreneur, and sometimes it makes some problems in practice with proper putting the things to the right place. I think that it's possible to solve this problem on the level of agricultural code, as Dr. Lis said, but I think it's worth discussion also with the problem of regulation of civil code, because it's also a very important issue. What are the characteristics of the contract of cultivation farming contract? Well, it is a bilaterally binding agreement. This agreement is payable. It's an automatic agreement. It's based on Roman formula. Do this, I give you in order you give me. It's a causal agreement, and it's agreement business to business relation. And in this respect, the services rendered by parties should be of proper diligence, as the civil code stipulates in such a situation. The very important question is, what are the benefits for the farmer from a farming contract? It's a very important kind of agreement for a farmer, because if he has written down a contract, he's sure that he could sell his production to the contractor. he can get payments in advance. It's also very important because agricultural activity is quite expensive. A lot of funds are needed at first, so he can finance his activity by the agreement with the contractor. A farmer avoids the risk of wrong choice of production. He can get various additional benefits from the contractor. And last but not least, the receivables of the concluded contract could be used as a collateral for a bank loan if the farmer needs more money to start his activity. There are also some benefits for the contractor. The contractor has the surety of acquiring the goods he needs. He can get lower prices. He can get control over the process of producing goods. Nowadays, it's a very important issue because there are strong demands for quality of farming produce. So, in order to be sure that the goods are of the highest quality, contractor can control the process of producing such goods. But of course, there are some other benefits, and I'd like to tell about them later on when I'm going to describe detailed aspects of this type of contract. The farming contract involves a lot of risks: agrobiological risk, drought, flood, bad weather risk of animal epidemics, or risks of plagues in case of another activities of farmers. There are also so-called civilization risks such as embargo, market risk, and so on. And it shows that a proper balance between the position of a farmer and of the contractor is of very importance in regulation of such a contract in the civil law. Agricultural production is based on agrobiological cycle, and if production is not possible to be performed due to circumstances for which neither party is responsible, the present regulation of the civil code stipulates that the farmer is obliged to return the received advances. The question is it proper or not proper balance between the parties of the contract? I think that we could discuss this problem very carefully, because if farmer has to return back advances, we must bear in mind that he has to pay later the cost of investigation. He has to pay for fertilizing, sowing, rents, and so on. He has to pay back bank loans. He has to pay his workers, and of course he has no income. So the question is, could we discuss about completely different balance between the farmer and the contractor? And my suggestion, the referenda, is to discuss, for example, such a regulation. The obligation to return does not apply to properly used advances and additional benefits previously received from the contractor. I think that it's one of many questions we could ask about the regulation of farming contract, but this is a very good question to show that we should discuss the problem very carefully. Another thing we could discuss to be changed is the definition of the farming contract. We could define this problem as a situation when agricultural producer farmer undertakes to produce and deliver to the contractor a specified quantity of agricultural products of certain type, and we could add to the definition of this contract unless he is prevented by objective circumstances beyond his control. Why is it so important? I think it is rather obvious statement, but if there are any obstacles which have external character, the farmer is not obliged. But in practice, we could observe such a situation that contractual penalties are used by contractors, in order to pay less to the farmers. And if the legislator would underline that production depends not only on the ability of the farmer, but also on the external circumstances. And if these external circumstances avoid fulfilling the contract, the farmer is not obliged. I think it should be underlined and it should be listed in the new regulation of the farming contract. I think that another question we should ask is about additional benefits for the agricultural producer. The list, which is presently in the civil code, I think it's a little bit outdated. I think that we should discuss proposal about new types of benefits which could farmer get from the contractor, and I have some proposals in my presentation. And of course, there are also some other concepts of certain changes. I think that sometimes it's a problem because a farmer uses a very simple form of agreement, and in fact, the party who gives the agreement to be concluded is the contractor. I think it could be changed a little bit if, for example, the act will give competence to the Minister of Justice to issue an optional contract form, and if both parties decide to use the form, this optional form will be the layout for the contract between the parties. Of course, I have some more ideas in the farming contract, and I'd like to present them later on during the next seminars. Thank you for your attention.
Dear Professor Adamus, thank you so much for your presentation. I would like to draw your attention, the attention of other colleagues, that your presentation was quite delega ferenda proposal focused, and it's good because the Institute of Justice especially asked us to provide and determine this kind of delega ferenda proposals, and of course we are going to do that. Thank you so much. And now I would like to invite Dr. Czirski to deliver his presentation. Dr. Czirski, the floor is yours.
Thank you very much. Can I ask Professor Adamus to close his presentation, or can I close it? Or oh, thank you very much. I am trying to, yes. Can you see my presentation?
Yes, but not the full screen version, but the part. Yeah, now it's perfect. Yeah, it's okay. Thanks.
Okay. Thank you very much for the opportunity to present my research concept and my future analysis in this research group. In the first presentation of mine, I would like to emphasize the main points that I will analyze in my book chapter, and I would like to frame my analysis in order that we could understand better the situation of agricultural producers concerning their commercial relations with buyers, be them processors, wholesalers, or retail chains. And first of all, I would like to emphasize some basic introductory remarks concerning the agriculture and food supply chain. The agriculture and food supply chain is an umbrella term. It is highly complex, so it is really difficult to regulate the whole food supply chain in a coherent way. there are many subsectors of agriculture. It is quite relevant that we are speaking about, for example, tomato production or wheat production and the sales of them. So it is highly complex, and there is a difficulty to regulate the whole agricultural sector in one. So there must be some reasons to establish certain regulations concerning certain subsectors, and this is a difficult task of the Hungarian and all kinds of national and EU legislation, that the agricultural sector consists of many subparts, and we have to be aware of these different kinds of products to regulate them in a better way. Another important characteristic of the agriculture and food supply chain, that nowadays the whole supply chain is longer and longer. So there are several steps from the producer to the consumer. There are long supply chains, which means that many middlemen, for example, wholesalers and retailers, all have their profit margins on the price of the product that is sold to the final consumer. And it is not an accident that there are many initiatives in the European Union that shorter supply chains should be established, because it would be better for the farmers to be closer to the final consumers, and the farmers would not be vulnerable to middlemen, and it would make their situation much better. And there are many types of state aids, and there are many initiatives to shorten the supply chain. Another characteristic of the agriculture and the food supply chain, that there is perfect competition between producers. There are many producers, they all compete with one another. However, both upstream and downstream, from the perspective of producers, we can see oligopolistic trends. There are concentrated processing markets. There are quite concentrated input markets, and also the retail chains and the retail market is becoming more and more concentrated, and it means that there are many farmers who are in a position that they have to choose only from a few retail chains, and it makes their position much more difficult. And there are only a few processors, and it means that they have no choice to whom they would like to sell their produce, but they have to consider only a few buyers who they can sell their agricultural products, and this results in a much more position for them, because they lack bargaining power. So there are many problems from the perspective of producers. Of course, production is vulnerable to weather and climatic conditions, and it means that there is no predictability of agricultural production, and it is really difficult to find a stable equilibrium position between supply and demand. In some year there are oversupply, in some year there are undersupply, so it is really difficult for producers to produce the appropriate quantity in each year, and there are many risks related to weather and climatic conditions that make it almost impossible for them to find the appropriate quantity to produce. Of course, this results in volatile prices. Agricultural production is a typical sector that has so-called cobweb cycles, which means that the large amount of time passes between the decision to produce something and its arrival on the market, and it causes price fluctuations. And this comes with the situation that producers are not price givers, but price takers. And it shall be emphasized that they are not price givers. However, they are the ones who should set their farm grade prices, but they are not in a situation, because of their lack of bargaining power, to determine their prices. And the one undertaking who can dictate the prices is the buyer, for example, a processor or a wholesaler or a retail chain. And in many cases, producer must obey to these buyers' wishes, because they are not in a situation to determine their own prices. The lack of bargaining power results in different forms of buyer power abuses. So when producers face buyers in commercial relations, there are many forms of trading practices that are detrimental to the producers. And another important factor is that producers are the risk absorbers in the food supply chain. They are the weakest in the whole food supply chain, and it means that when some risks arise, they will be the ones who will pay the so-called prices of that risk. For example, it's enough to think of the COVID-19 or the war. And for example, in Hungary and also in Poland, we can hear that the oversupply of Ukrainian wheat results in a very bad situation for Hungarian and also for Polish wheat producers, and who are the ones who will absorb the risks. The farmer is the one who will suffer from certain policy decisions. The central question of my book chapter is that how does private law, in particular contract law and competition law, protect producers against the so-called against the mentioned problems? And in accordance with what Professor Adamus mentioned, a private law and civil law also consists of commercial law, also in Hungary. So it's a general remark, and I am really glad that we will use the same terminology in that regard. But my central focus will be on contract law provisions and competition law provisions, which I mean in a broad sense, because under competition law I also mean antitrust law, which is the conventional competition law, and also other unfair trading practices that are beyond the scope of the conventional competition law regulation. The structure of my book chapter is you can see on this slide. After an introduction, I will try to map the national agriculture-related strategies. After that, the legal forms of conducting agricultural activity, and the basic principle, the freedom of contract. And the main analysis is divided into two parts: the civil law section, where I will delve into agriculture-specific contract types, such as the sales contracts. Here I would like to mention that this sales contract will be almost the same which was mentioned by Professor Adamus, but I think that the Hungarian regulation is not so detailed like the Polish one, but this sales contract in the Hungarian Civil Code deals with the question that what happens when the producer undertakes to produce a certain agricultural product before it was and tries to sell it before it was even produced. And another contract type is the service contract, which will be analyzed in my book chapter. And there are further contractual provisions that I will analyze. Here it is worth emphasizing that the Hungarian regulation does not only consist of civil law provisions, but also public law provisions, and certain provisions are not codified in the Hungarian Civil Code, but in a national legal act which is of public law nature, and which comes with public enforcement. The other main part of my book chapter will be the chapter of competition-related regulation, consisting of conventional competition law, concentrating on the exemption under the prohibition of anti-competitive agreements, and the other one will deal with unfair trading practices that go beyond the scope of competition law. I would like to speak about Hungary's agricultural strategic documents and a few basic data that I have found in connection with our country's agricultural sector. As you can see, the sector's contribution to the GDP is 4.5%, which is relatively high. In this regard, we are in the top 5 countries among EU member states, and I think it makes and it creates an enhanced responsibility of legislation and policy making to deal with the protection of agricultural producers, because they contribute to the gross domestic product at a relatively high rate in relation to other EU countries. I have to also mention that prima facie a high level of protection is provided to farmers. So legislation and then policymakers are aware of the problems faced by farmers, which means that we have a quite detailed and good regulation that are aimed at protecting Hungarian producers. However, strategic documents are quite rare in the last few years, but I have found some sporadic mentions of business relations in the policy documents. For example, in the mid-2010s, there was a medium and long-term food development strategy that set out the objective of establishing equal market positions in the food supply chain through promoting vertical and horizontal cooperation. Of course, this is related to the prohibition of unfair trading practices and the exemption under the prohibition of anti-competitive agreements. And of course, this strategic goal is established through legislative acts that aim to counterbalance the lack of bargaining power of producers. the medium and long-term food development strategies established certain means to handle the situation, and you can see the list on my slide. For example, the review of legal conditions and the drafting of supporting legislation where necessary, and there are many more. For example, promoting joint market access for producers, and they all try to achieve that producers find themselves in a better market position, which enable them to determine their own prices and to not fall victim of unfair trading practices. In 2019, there was a government order on the promotion and coordination of the digitalization of Hungarian agriculture and on Hungary's digital agricultural strategy. And it declared that it is necessary to develop digital-based distribution and sales, sharing economy methods to support the sale of domestic agricultural products and the recycling of agricultural waste, to shorten trade chains, and by exploring the possibilities of using blockchain solutions. It is a very forward-looking declaration, and as you can see, the shortening of supply chains is also mentioned here, and I think it would be quite forward-looking to introduce certain blockchain solutions to alleviate the situation of farmers, and the crucial solution would be to provide them market information with blockchain technology in order that they could get access to more markets, and they could have more full and more complete information about the situation of others. And of course, this would make the situation easier to sell their products. Hungary's digital food industry strategy shed lights on the fact that the government does not take a simplified approach to agricultural production. As you can see, there are three main roles that the agricultural sector should play in the economy according to the government. One of them is production, the second one is ensuring the employment of rural areas, and the third one is the preservation of agricultural landscapes. It is crucial to mention that a holistic approach is very important for the protection of agricultural producers, because if we see the market situation, if we only look at their situation from an economic perspective, of course there may be some arguments that many farmers are not efficient and they should not be provided with protection. But if we see other roles in the agricultural sectors, and we accept that they not only produce certain basic food staples, but also has other functions such as the reservation and the preservation of landscapes and the employment of rural areas, there we have much more arguments to provide protection for them in commercial relations. Because with this, we go beyond economic efficiency, and we also emphasize certain values that are inherently in the production methods of agricultural producers. Furthermore, High Politics also expressed its commitment to the protection of producers, and in his annual assessment speech in February 2023, Hungary's Prime Minister explicitly said that they would keep the promise they had made to the countryside and launch unprecedented developments, and they would provide more money than the Hungarian countryside had ever seen. As you can see from these policy documents and these declarations, the situation of agricultural producers is not a neglected issue in policymaking processes, and the sector's development hand in hand with the improving of market possibilities for farmers are of great importance in Hungary, which means that the framework producers operate in has a positive atmosphere that aims to support them from not only a legal but also an economic viewpoint. And I will delve into the legal analysis of this legal framework, and I will try to explore the strengths and weaknesses of the current legal regime from a contract law perspective and from a competition perspective, and I hope I will be able to formulate certain proposals and establish and set out the best practices that are worth of taking over by other countries. Thank you very much for your attention.
Dr. Czirski, thank you so much for your contribution, your presentation. It was similarly valuable as the others' presentation. Dear colleagues, of course, now I provide an opportunity if anyone would like to ask somebody from the group. Professor Adamus, the screen is yours.
Thank you very much. I'd like to add just one thing. In Poland, there is public competition law and private competition law. And there is a very strong link between, in my opinion, of course, between private competition law and public competition law. Because if we introduce new kinds of unfair competition deals, if they are repeated, they make a practice which is under the competence of the Polish antitrust law. And in such a case, Polish antitrust law can give administrative responsibility to the entrepreneurs who make such a practice. So if we change something in private law, we in fact influence the public law very strongly. So I think that your part and my part will have many more common points. Thank you.
Thank you so much. I think that Professor Adamus noticed it's essentially as to the so-called third part of the planned book, and thank you so much for this support. Dear colleagues, any other questions or comments? If not, first of all, I would like to draw your attention that our next open seminar is on 8th of June. Therefore, we are waiting. I am waiting for you at that time, and of course, for your presentation. And now, before the closure of the present opening seminar, I would like to express my gratitude to the Institute of Justice, which provided this opportunity for us. And of course, I would like to express my gratitude to you as well. Thank you so much that you honored me and other team members with your presentation and contribution. The colleagues, that is a high time to close the open seminar. Thank you so much.
Thank you.
Thank you very much.
Have a nice day. Have a nice night.
Bye.
You too. Thank you.
Thank you. The
Goodbye.
same to you.